Good afternoon, and for those attendees on the West Coast, good morning. I'm Chris Larus, Chair of the Minneapolis-based IP and Technology Practice at Robbins Kaplan, and I'd like to welcome you to the second in our two-part series of webinars on best patent practices in a transforming environment. Today's second webinar in the series will address evolving strategies for patent enforcement and licensing. Our presentation today will offer a combination of perspectives on how innovative companies can most effectively adapt their approaches to patent licensing and enforcement to maximize value. Our goal is to offer strategic insights into this rapidly changing subject matter, not simply to offer news of the latest patent cases. First, a note about our presenters today. Robbins Kaplan is one of the country's premier trial firms. With offices around the country, we're focused on representing clients in disputes before federal and state courts, arbitration tribunals, and in administrative trials before the Patent Trial and Appeal Board. We also represent clients in developing and managing licensing campaigns for patents and other intellectual property. For the past 25 years, I've represented innovative companies in a wide variety of patent, trade secret, trademark, copyright, and licensing disputes. With me today is my friend and colleague, Tim Bianchi. Tim is a principal with the Schwegman, Lundberg, and Woessner firm. The Schwegman firm is dedicated to the procurement and management of patent rights for its clients both domestically and internationally. Tim has been procuring patent rights for technology clients for the past 24 years, but is also engaged in post-grant reviews and supporting litigation teams on patent issues. We're fortunate to have a number of experienced IP practitioners attending today's webinar, and we welcome your questions and comments throughout the presentation. Our live chat window can be found in the lower left-hand corner of your screen. Feel free to submit questions through this window, which will be addressed during or at the end of the presentation. Presentation slide decks and speaker information can be found in the lower right-hand corner of your screen. An on-demand recording of this webinar will be available 1 to 2 days after broadcast. And finally, as we get going, a note about CLE information. This course is pending approval by the Minnesota State Board of Continuing Legal Education for 1 hour of credit, and you will be notified once approval is confirmed. So now with that, on to our presentation. As we discussed at some length during our last session, the environment for patent enforcement and licensing has transformed rapidly and substantially over the last several years. And we're not going to go through each of these changes today, but it helps to set the stage for our discussion about evolving strategies. Certainly, the advent of IPRs and other post-grant proceedings under the American Invents Act has substantially changed the flow and nature of patent licensing and enforcement. Similarly, the substantial increases to the number of challenges to patent-eligible subject matter, changes to standards for definiteness, changes in the law governing patent damages, and increased difficulty in obtaining injunctive relief have substantially altered the risk profile for licensing enforcement, both for IP rights holders and for potential licensees or litigation defendants. So now I'm going to, in light of those substantial changes, I'm going to talk about the evolving strategies for licensing and enforcement. And I'll start first with one of the core tasks in any licensing and enforcement effort, which is identifying the assets for potential licensing and enforcement efforts. And whether we're talking about disputes between competitors where injunction is the primary focus, or we're talking about efforts in which monetization of patent assets is the primary focus, certainly there are changing strategies around asset selection. At the forefront of any decision around asset selection is a focus on the clarity of claims and descriptions in the patent to be asserted. and also whether or not there is clear and demonstrable infringement. Those have remained consistent throughout the time that I've been practicing in this area. However, I would say there's an increased focus on making sure that claims can be clearly articulated early on in licensing discussions, and the scope of those claims as reflected in the written description of the patent are clear. One area in which there's been a substantial change around asset selection is an increased focus on an early stage validity assessment, especially with respect to 101. And we've obviously seen substantially changing standards around 101, and as I'll talk about later, the way in which 101 challenges are likely to be raised in disputes has changed substantially as well. And that's put an increased focus on making sure that 101 issues are carefully vetted before licensing efforts or enforcement begins. Another area in which we've seen substantial change around asset enforcement or asset selection is with respect to portfolio size, the number of patent properties that are the focus of a licensing or enforcement effort. We've largely seen a transition away from single high value patents being asserted alone as part of a campaign certainly in major litigation or even effective licensing efforts. More often, we've seen an increased focus on a portfolio of unrelated patents being presented for licensing and enforcement efforts that help to mitigate some of the risks around IPR and other validity challenges that are often raised at early stages of proceedings. Another change with respect to asset selection has been an increased focus on whether or not there remains open prosecution with respect to the patents that are at issue. Open prosecution has always been an advantage to properties that are going through licensing and enforcement efforts, but certainly we see this as an issue of increasing importance as almost all patents that are the subject of significant high-value licensing and enforcement efforts are likely to undergo some type of validity challenge or AIA-based post-grant review. That puts an increased premium on making sure that at least some of the patents that are in the portfolio being asserted can address prior art challenges that might come up early on in the proceeding. So these are core considerations for any type of enforcement effort, but there are also additional considerations that come into play when the primary focus is on monetization. Not all patent disputes are focused on monetization. We regularly represent clients who are involved in disputes with competitors where the primary focus is on stopping the infringing behavior and keeping the market clear for competing products. However, we also represent a wide range of clients who do have a primary focus on either non-core licensing efforts or enforcement against a wide variety of infringers. Where monetization is the primary focus, additional considerations around asset selection apply. One of those considerations is whether or not the claims are directed to a high-value infringing market. And this can have a couple of aspects to it. One is certainly the question generally of whether the technology area is one which will support the type of margin that is likely to lead to a relatively high reasonable royalty. There are certainly a wide variety of technologies that are out there that might be very patentable and might have significant patent rights, but if they don't attach to a market in which there is a significant margin for the operators within that market, you're unlikely to drive significant value in licensing and enforcement efforts. Another consideration that falls under this heading is whether the claims themselves are directed to players within the distribution chain that are realizing the largest portion of that profit within the market. Are the claims directed to component suppliers who might have a relatively constrained margin or overall price point, or are there claims that are directed to the sellers of ultimate products that incorporate perhaps multiple features of a compiled product, but enjoy the higher royalty or enjoy the higher um, profit margins that will support a higher royalty. A second closely related thing is there a credible damage calculation for the infringing product? And I'm going to talk about that secondly in just a moment. And then the third consideration that comes into play is geographic scope. Patents within the United States remain a primary focus, certainly for our practice, but even within international patent licensing and assertion, U.S. markets remain the primary market for, for patent damages. However, we're increasingly seeing clients who are interested in a multi-jurisdictional enforcement effort focused on making sure that their asserted portfolio includes properties that provide patent coverage in other jurisdictions that perhaps are more hospitable to injunctive relief. This can create an important additional consideration if we're talking about a high value geographic market in which there's a real threat of injunctive relief, even if the patent holder and the target are not directly competing. Interestingly enough, markets that are of particular interest here are patent coverage in Germany and interestingly, even in the People's Republic of China. While overall, certainly in the past, China was seen as a market that was not a particularly good one for patent rights holders, in the last few years, we've seen a substantially increased amount of patent enforcement activity in China and a fair willingness of many Chinese courts to grant injunctive relief, which can certainly change the risk profile in that important high value market. So patent holders that are looking to maximize monetization returns often and increasingly are looking for scope of coverage in their patent portfolio that extends beyond the US market into these other markets as well. Damages. A note, one additional note on the importance of a sustainable damage theory. Among the significant changes that have gone on in the patent assertion area is an increasing exactness demanded by the Federal Circuit and by district courts around the United States for a quantifiable and supportable damage theory that links the technical improvement to a specific quantified economic benefit in order to support a particular royalty rate. That economic benefit comes in a whole host of ways, but including notably the ability to pass on some type of a pricing increase, the ability to have the product itself operate in a better, cheaper, faster manner that has a demonstrable economic result. But most significant patent enforcement and licensing efforts these days are really directed to a patented feature within a multi-featured product, and the ability to clearly tie the technical improvement to a specific quantifiable economic benefit is absolutely critical, both at the licensing stage and, if licensing is unsuccessful, at the ultimate enforcement stage. I'd like to transition now to a short discussion about some of the unique aspects around standard essential patents. And in the last few years, we have seen a substantial increase in licensing and enforcement directed to standard essential patents. And as you may know, standards are widely adopted across a very wide range of industries. Certainly, much of the litigation focus on standard essential patents has been directed to communications technologies of one type or another in consumer electronics, but standards themselves are seen in the chemical arts, they're seen in medical devices. And standard essential patents bring with them some potential advantages. Certainly one of the main ones for those that are seeking to assert these patents is a reduced risk of non-infringement, where the claims of the patent read closely to the actual requirements of the standard. The risk that a standard compliant product does not, in fact, infringe the patent is certainly a lower risk. And that's one of the main reasons that patent holders look to assert patents of these types. But there are other additional benefits. Certainly, standard essential patents enable broad-based enforcement against potentially a large damages base or a large number of potential infringers. This can result in certain economies of scale when pursuing enforcement and licensing of these patents across players within an industry. Standard essential patents where there's a close alignment between the patent's claim language and the language of the standard itself can enable a fairly straightforward pre-suit infringement assessment based on publicly available information, and that can reduce both cost and risk in that pre-suit phase as a patent holder is deciding whether or not to assert a given standard essential patent as part of its portfolio. And one thing that's also certainly important to understand is that the licensing market for standard essential patents continues to mature as the standard becomes increasingly implemented. Oftentimes there are many patents that might be declared essential to the standard, and industry players engage in a certain level of, in many standards, engage in a fairly extensive level of cross-licensing or out-licensing of those standard essential patents, and that can be helpful in terms of establishing royalty rates for standard essential patents within a given industry focus or standard. There are, of course, some particular challenges that are somewhat unique to standard essential patents. And one of the main ones is that the law, the decisional case law around valuation of standard essential patents remains largely unsettled. Although industry standards have been around for a very long time, we've only recently saw a real growth in the litigation and court-focused valuation of standard essential patents. Decisional authority that we do have demonstrates, of course, that valuation cannot be based solely on the necessity to practice the standard. Rather, valuation has to be based upon the incremental advantage of the patent itself. Where the valuation of the standard essential patent is based on premiums associated with the standard overall, it's necessary. There's an additional burden that patent holders have, which is to show the value of the asserted patents relative to other standard essential patents. So it may well be that that through economic analysis, you're able to show that patents or that products that comply with a given standard have a set of advantages collectively over other types of prior products, and that those advantages tie to some discernible economic additional cost or economic receipt revenue that's attributable to products that enjoy those benefits. But then it's necessary to go the step farther and actually show the relative value of the patent holders' asserted standard essential patents as compared with those of other entities that have declared their patents essential to the same standards. Closely related to this analysis is the fact that targets of enforcement efforts involving standard essential patents often try to raise concerns regarding the burdens of a royalty stack of standard essential patents in order to limit exposure to licensing and enforcement efforts. One other thing that's certainly unique about enforcement of standard essential patents is that the nature and pace of standard setting organizations, or SSOs, results in prior art risks and evaluations that are different than many of the other types of non-standard essential patent assertion matters that you might be involved in. Standard setting organizations tend to move very quickly. They tend to involve a wide range of competing submissions by industry participants, some of which might offer very incremental advantages one over the other and move at a very fast pace. And so oftentimes the activities of the standard setting organization itself prove to be the primary focus of prior art searching when you're talking about standard essential patent cases. Now I want to shift gears a little bit and talk about another way in which asset selection is changing in this rapidly transforming environment, and that's the increased use of data analytics. Like most industries, big data is becoming an increasingly impactful way in which decision makers in the patent realm make their decisions. And I would imagine that most of us are very familiar with the use of data analytics that might be used in enforcement in order to assess the selection of venue for a case, compare either certainly a number of services that are available, docket navigator is one, lex machina is another, that allow patent holders or those involved in patent litigation or enforcement on either side to evaluate the relative advantages and burdens of individual venues. These kinds of services can provide helpful information when evaluating licensing and enforcement activity of individual targets within a licensing campaign. They can help predict motion and case outcomes to varying degrees, and they provide for in-house counsel a potentially powerful tool for evaluating the performance of their outside counsel by allowing a view into success rates across the various patent matters that their counsel have been involved in. In addition to these disputes-focused analytics, increasingly we see clients who are interested in using analytics as a way of evaluating which patents within a portfolio should be selected for licensing and enforcement. And this can be very helpful both in terms of selecting patents within a large portfolio or putting a smaller portfolio in context. And while no analytic tool itself can identify which patents are likely to drive value, the use of analytic tools can provide a powerful edge and a statistically significant view into how different types of technologies or different types of patent attributes are likely to fare in licensing and enforcement efforts, and I'll outline a couple of these. As we talked during our last session, overall, the availability of IPRs as a means to challenge patents has substantially changed the risk profile for patent licensing and assertion. And we know from statistics that are released by the Patent Office that approximately 72% of all petitions for IPR are granted. And where granted, only or fewer than 30% of patents actually survive with one claim intact. That can present a very challenging gauntlet for a patent holder to run in any enforcement effort. But not all patents and technologies fare the same. So what I'm showing you now is as part of our a proprietary analytic tool that we developed at Robbins Kaplan that we call Pinpoint IP, that provides patent holders with the ability to dive more deeply into identifying the attributes of patents that are actually likely to drive favorable results. This is an odds chart, and this shows by looking at different technology areas, it allows us to examine where technology type can drive different results than the average numbers that I just referenced. So across all types of patents, we know that 72% of the time a petition will be granted. But there are statistically significant differences based on technology type. The bold colors here reflect where there is a statistically significant difference from those general statistics. And so this allows us to see that within the biotechnology or organic chemistry field, 15% of the time, again, a statistically significant result, there's a lower chance, or there's a 15% lower chance that a petition will be instituted than the average statistic. In comparison, and these are arrayed kind of in the degree to which they're favorable to the patent holder, when we're talking about semiconductor technologies, there's actually approximately 10% greater chance that an IPR petition is going to be granted. This in and of itself doesn't tell you is there one patent that is likely to drive value? But what it shows is a 25% difference based solely on technology about whether or not a given patent is likely to be instituted if a petition is filed. And if we look again more deeply at what happens when petitions are granted, we see many of those same trends match up. So not only are the arts in biochemistry, biotech and organic chemistry less likely to be instituted if a petition is filed, but where instituted, they're twice as likely to survive than average patents. Again, the goal here is not to identify a specific patent that is likely in and of itself to drive value, but it does provide a statistically significant edge when determining what types of patents within a portfolio to pursue. With what we have, these are based on the general technology centers into which all patents are divided by the Patent Office. We have the ability to delve more deeply into tech center units and ultimately general art units that provide a more granular view of what types of technologies are likely to survive IPR. And we actually see in those analyses some significant differences within tech centers. So some of the tech centers here that are shown in gray as not having overall a statistically significant difference have those results in part because they're offset with some general art units or tech center units being more likely and some less likely to be instituted. Another way in which we use analytics in working with the client is to help to identify patents within a portfolio that are likely to be good licensing targets. And this is just simply one example where we took a subsection of a patent holder's portfolio and arrayed it, one looking on the vertical axis about the remaining time left for patent assertion. We compared that along the horizontal axis with forward references, not just looking at the average number of forward or the ultimate number of forward references, but controlling for time and technology area and the level of patenting within those technology areas to identify a percentile where a given patent fits within percentile. And then the bubble size to identify a percentile where a given patent fits within percentile. And then the bubble size reflects the size of the family, and the color here identified whether or not patents within the family had open continuations. This provided a quick look now looking at the upper right-hand corner for the client to identify those patents that had long life, were frequently cited, more frequently than their peers, again controlling both for age and art, and also had significant family size and open continuations. The goal again here, not to identify with this single look what patents to assert in licensing or enforcement, but it provided a way of putting the portfolio in an important context when they're deciding which patent properties were worthy of a more detailed look. We then are able to distill, going from the portfolio to the individual patent, kind of a one-page view produced solely in an automated way that provides important information about the patent, pulled both from the patent itself, the file history, and comparative information that again is designed to help clients identify which patents within this portfolio were worthy of the much more detailed qualitative eyes-on analysis that we ultimately performed in helping them figure out which patents to assert. So walking you through this, we pulled some basic information from the file history regarding the size of the family, the number of claims, priority dates, dependent claims, that kind of stuff. We were able to look and pull into a single place which entities were most frequently citing this patent within the last 2 years and how often they cited it. We were able to do a comparison between the language of the claims and the language of the specification in order to identify potential 112 issues and identify where there might be claim terms that were not clearly defined within the specification and where within the claims those terms showed up. And then importantly, we were able, again, to put this patent into some broader context. And here, working with the client, we identified 3 important contexts. One was, where does this patent sit in terms of specification length? Not across all patents, but across similar patents of a similar art. And this particular patent was in the 99th percentile of having a long specification length for its art. We were also able to see that this patent was in the 80th percentile for its number of cited references, again, controlling both for age and art, because we see significant differences in citation activity between, say, a mechanical patent and a biotechnology patent. This controls for those differences. And then we see that this patent is in the 97th percentile for forward references, again, controlling for age and art. The end result of this is not to suggest that analytics alone allow a patent holder to identify which patents are likely to drive substantial value, but rather to help clients go beyond an opaque spreadsheet and look more deeply and quickly at identifying where within a large portfolio are there properties that are likely to be significant drivers of value, and if we're dealing with a client with a smaller portfolio, understanding very quickly how their portfolio fits within a broader context. With that topic, I'm going to pass it on to Tim, who's going to discuss some specific enforcement issues relating to AIA reviews.
Okay, thank you, Chris. I appreciate that. One quick question I have about those analytical tools is I expect those tools were developed at Robbins Kaplan. Those are not from another package, correct?
Right. So we have a long-standing history of working with a number of different analytic tool providers. What we ultimately saw was a need for some more fine-tuned analysis, and these are all part of a kind of a suite of analytic tools we offer under the brand name of Pinpoint IP that we developed proprietarily, and we
Understand.
often discuss with our clients.
Very interesting. Thank you. Thank you to everyone else for tuning in to the webinar today. It's quite a good representation of the patent bar here on the call on the webinar, so appreciate that. I was very fascinated by the data that Chris just presented, especially with regard to the PTAB, and this next module of the discussion of the webinar is going to be primarily about the changes that we've incurred in our practice as a result of PTAB proceedings from the American Invents Act. The first couple graphics that I'm going to present are really, there's no real new news about this. What I'm just going to do is lay the groundwork for the concept that things have really changed since the American Invents Act and since the institution of these trials. What we used to do in our practice is learn how to draft patents from things that happen in district court or in the Federal Circuit or the Supreme Court. And so the typical process was to procure patents, assert them, litigate, and learn from that, and cycle that information back into the procurement process, hopefully to create a better work product. Well, since the implementation of the AIA trials, we now have an extra hurdle in this little circle of information. And what I did here is I showed a very simplistic change where we have a first hurdle that is typically associated with a PTAB proceeding to test the validity of the patents in the PTO at the administrative trials in the PTO prior to going into litigation, typically associated with a stay. Now, of course, in cases where the PTAB is the end of it for the patent owner, there should be an arrow going from hurdle 1 right to the procurement side, and hopefully we're learning from those lessons as well. But in general, we have a brand new set of factors to consider for patent procurement. And the proceedings, as you know, were enacted back in September of 2012. So we're coming up on 5 years of AIA trials. So we're starting to get some really good data. And the next couple slides are going to be kind of to present some different ways of looking at the PTAB statistics, just as a kind of a touch point. Thanks to the folks at Docket Navigator, I was able to obtain a chart, their permission to put out here, to show kind of the impact of AIA trials on the filing of new patent cases. And as you can see, the green bars represent district court filings. The blue bars are the PTAB. The red bars that are a smaller fraction are the ITC proceedings. But as you can see from this chart, quite a bit of activity in the PTAB since the inception of these trials in 2012, late 2012. And Docket Navigators also put into the chart their prediction of what will happen in 2017, as we're currently only a fraction into the year. And they're predicting basically a little more fall off on district court filings, a little increase in PTAB proceedings. So time will tell if that prediction will come true. But as of today, I think their prediction on PTAB proceedings is a little aggressive based on the filings we're seeing to date, but we'll talk a little bit more about that in a slide or two. So this next chart was taken from the US Patent and Trademark Office statistics that they compile from time to time, and it shows the level of IPR and CVM filings and PGR filings. And as you can tell from the chart, of course, fiscal year 2017 is only partial, but since the PTAB, since the Patent Office's fiscal year starts on October 1st and not on January 1st, we are 5 months into that. So statistically, that represents 5 months on that last set of data in the histogram. As you can see, PTAB filings have tapered a little bit. CBM has tapered off quite a bit, and PGR is still trying to get jump started, has not quite done that yet. It's a good question as to exactly what's going on with CBM filings and why they have tapered off. Part of it may be due to the fact that we are in an environment where a lot of patents that were asserted in the beginning of the enactment of the AIA trials have been instituted for review. And part of it is also a little bit of a narrowing by the Patent Office determination of what a CBM review is, given the recent decision in Unwired Planet versus Google by the Federal Circuit regarding what constitutes a CBM. As you might be aware, the PTAB was using a pretty broad standard to institute CBM and was stating that the inquiry was whether the patent claim activities are financial in nature, incidental to a financial activity, or complementary to a financial activity. The problem that the Federal Circuit identified is that the incidental or complementary language used by the PTAB is not found in the statute, and thus they sent the case back up on remand. Perhaps another factor in CBM filings is that it is subject to an 8-year sunset from the enactment date of September 16th, 2012. So filings on CBM will no longer be received by the office after September 16, 2020. Chris mentioned some resources for doing case research, and one of them is Lex Machina. And courtesy of Terry McNeil, we do have some charts to present as well. And on this first chart, you can see since inception of the AIA, the level of IPR filings and how it has consistently increased until perhaps the last year or so, where it seems to have tapered off and kind of leveled out. CBM, as you can see from the green curve, is waning, and those filings are diminishing. Lex Machina also provides some real helpful visual graphics to try to determine statistically where we're at given a different time range, any selected particular time range that you'd like to select. This particular graphic, and I'm sorry if it's a little bit of an eye chart, it's a little bit of small print, but it relates to IPR petitions filed from the inception of the AIA up till 2016, but only in proceedings that were terminated by 2016. So if there was a proceeding that was pending at the end of 2016, it's not counted in this in these statistics. But if you look at the chart, you'll see that roughly 2 out of 10 filings were denied institution, or 20% right out of the gate. Roughly 2 out of 10 were settled or technically dismissed, and that leaves about 6 out of 10 instituted for review, or 60%. Of those 60% instituted for trial, about a quarter of them had all the claims canceled. In about 11%, at least some of the claims were upheld or all the claims were upheld. 24% represented the discharging of the case by joinder, settlement, or other disclaimer by the applicant, by the patent owner, I'm sorry. But significantly, almost none of these cases resulted in amendments that were motions to amend that were granted. And as I mentioned, you can take the tool and use it over different timeframes and look at different things. And this next snapshot is more of a determination of what the statistics are over a given year from 2015, for example, about the heart of when the PTAB filings were ongoing. The problem you have with all these statistics, of course, though, where you get into trouble, is that these proceedings typically take about 18 months because you have a first petition period where a petition's filed, and then you have 6 months before you're going to understand whether or not it's instituted typically. And then if it is instituted, you're looking at a year from then to get a final written decision on typically. And of course, on given appeals and other things, consolidation of cases, all those timings can change. But the tool is very handy to try to take a look at different statistics. I'm just going to finish up with a few slides on observations, and we're going to keep it big picture today because we only have an hour to work in, but also we're just trying to give some high-level guidance on what we're seeing in the PTAB. So as we looked at the statistics, those IPR filings remain robust. BBM is falling off. PGR has not gotten going yet. Part of that's due to the fact that it has to be a first to invent filing, first to file filing, and so those have taken a while to issue. There was a change in the rules as of April of last year, where pre-institution patent owner testimonial evidence has been allowed to be submitted, but statistically we're not seeing a large impact yet that dictates an outcome, whether that evidence has really changed or moved the calculus of how the patent owner can make its case out to the PTAB. So the jury's still out on testimonial evidence in the patent owner preliminary response. We are seeing what I think, and this is my own opinion, a rise of patent-friendly decisions. So I don't think institution is automatically cancellation as it may have seemed in the early days of the PTAB. I think we're seeing a much more reasoned outcome from the board. Of course, claim amendments are still elusive, and you're not seeing many of those granted. And we've seen some very mixed decisions on estoppel, but so far the estoppel in the district court estoppel seems to be particularly weak based on the Shaw versus Creel decision. Again, that's a moving target. Just some general takeaways to summarize what we've seen here in the last, now it's going to be coming on 5 years here this September, but no surprise that haste makes waste in these petitions. So if you're a petitioner, a little bit of time doing it right is very important. Great prior art always reduces the cost of petition drafting and makes it easier, and the arguments are much more straightforward and easy to follow. Of course, the maximum that claims that you do not successfully cancel are made stronger always applies. And I think we're seeing an increase in petitioners having to work extra hard to make clear arguments for the board, because some of these patents are relating to some very highly technical areas. One of the good things that has resulted from the rule changes of last year is that petitions are now being tested on a word count as opposed to page count, which allows for more liberal use of graphics to try to depict the inventions at stake in the prior art that is being applied in the grounds. Finally, for petitioners, when it comes to setting up your petition, use of claim constructions, very careful use of claim construction can actually establish veracity or destroy it. So it's important for petitioners to think through those pieces of their petition as they're preparing it very carefully. Shifting to the patent owner, of course, the maxim that no review is the best review still applies, of course, and winning on institution is always the next best thing. But it does seem from at least anecdotal evidence that those cases that are instituted for trial have a much more favorable chance of survival later on a final written decision than ever before. I think practitioners are a little more, have a little more heightened concern about avoiding waiver in case they have to go up to the federal circuit. So you have to be careful how you structure not only your preliminary response, but your final reply. And I think that the AIA is constantly telling patent owners you might want to challenge the way that you're looking at prior art and how you're disclosing it to the patent office, because what used to work in the old school system of getting claims granted without regard to validity is really a difficulty for patent owners in the AIA world that we live in today. A few things that didn't change and from the implementation of the AIA is that continuations remain a valuable tool for patent owners or for patent campaigns. Carefully drafted claims are always going to be of value. That's was before the AIA and it remains after that. Ex parte reexamination is still available not only for a challenger but also for patent owner. That's always still there. The only change being that perhaps the CRU is a little less besieged with cases because their workload has gone down.
Tim, we have a question from the audience. Question is, many PTAB challenges involve Section 103. Has the PTAB changed how it's addressed obviousness considerations over time?
Thank you, Chris. I think that the PTAB has taken a more reasoned approach to obviousness challenges in the last couple of years here, especially in the last year. And we're seeing more defenses of the patent granted, especially on things like secondary considerations. And there have been some recent decisions that are encouraging for patent owners to know that 103 references are going to be viewed not only for the basics that they teach, but also in the context that those things are taught. Because it's pretty hard for a patent owner to come up with something that's so novel that no one would have ever possibly contemplated it. In fact, someone had to because they had to invent it at some point. So what's going on is the office is taking a much more reasoned approach. And just finally finishing up, I think the only other change that we're seeing, some of the changes we're seeing with the AIA is now IPR has become more of a threat than declaratory judgment to potential litigants. Uninformed and careless patent drafting is getting spotted by the board and it's getting punished. And now patent owners are facing six-figure upfront costs for defending these against these reviews. And so that those are changes that have kind of changed the landscape of patent enforcement. With that, I think I'm going to turn back over to you, Chris, to go over your next module.
Great. Thanks, Tim. So I'm going to close my part of today's presentation by talking about some practical impacts to the changes that we discussed at the outset and the impact of IPR and other patent trial and appeal board proceedings on litigation generally and efforts by patent holders to license and enforce their patents. And certainly, one key takeaway among practical impacts is that the changes that we've discussed have generally increased risks for patent holders. And those increased risks really manifest themselves in a couple of ways. Certainly one is the increased risk of an adverse result, either in court or before the Patent Trial and Appeal Board. But another way in which that risk manifests itself is the risk that licensing targets will refuse licensing overtures. And what I've certainly seen and both myself and in talking with clients that are very actively involved in licensing efforts is that it is a very challenging licensing environment, and many the ability to get significant deals done outside of an active disputes context is very limited. So how do IP rights holders mitigate? Is very limited. So how do IP rights holders mitigate those risks? Well, certainly careful asset selection when identifying the patents that are either going to be the subject of licensing or enforcement, or where an entire portfolio or a large portfolio is going to be the subject of the licensing and enforcement efforts, which assets are likely to be the lead ones that are identified. Carefully selecting and curating that group of assets is very important. That's the topic that I more or less covered earlier in the presentation. Closely related to that is an increased focus on curating a diverse portfolio. We have largely moved away from the situation where a single patent, no matter how well drafted, no matter how innovative, is itself going to individually drive significant licensing or enforcement results. More often, clients are moving towards presenting a diversified portfolio that has several properties across multiple families, so that if there are challenges either in court or in the AIA to the coverage, the overall licensing and enforcement effort remains. Numerosity, is a key aspect of this. Size of portfolio certainly matters. However, quality remains key, and if we look anecdotally at there are certainly licensing companies that are very active in the market, simply relying on the fact that they have large portfolios, although they may not be strong portfolios. That's not likely to win the day either. Quality is key, and ultimately the ultimate challenge to moving forward with licensing or enforcement is the ability to credibly demonstrate a risk of enforcement. That's what changes the balance of that risk. And then the last point I'll cover here is a change in overall strategy that we have undertaken and we see implemented generally in the market, away from serial targeting of enforcement efforts and more concurrent enforcement. Because of the unique risks around IPRs and other PTAB proceedings, there's been a shift away from the idea of choosing a single defendant, vigorously pursuing that defendant with the hope of obtaining a favorable result that will lead others to quickly license. Now there's an ultimate premium on moving forward. If you have multiple licensing targets or enforcement targets moving forward simultaneously, so that 1 year period in which they can pursue an IPR or other types of PTAB challenge is concurrently running, and targets don't have the ability to simply sit back and build upon the efforts that are that they see by co-defendants. A second very practical impact is that licensing and enforcement generally takes longer than it used to. Tim addressed this briefly when talking about this added step of a PTAB challenge becoming almost kind of the norm in virtually all significant patent enforcement and licensing efforts. Stays pending IPR, other post-grant review, are regularly granted. And in addition to that change, we see an increased level of motion practice that can also lead to delays in schedule. And I'll call out one area. I mentioned earlier that across the whole profile of changing risks, certainly the developing standards around what is patent eligible subject matter has had a big impact. There are large portfolios of patents that were, might have driven great value before Alice and are not worth much today. But in addition to that substantive legal change around what constitutes patentable subject matter, we've also seen a significant way, a change in the way that courts are dealing with those types of challenges procedurally. And this chart at the bottom of this page really makes this point well. And I apologize for the small text for those of you who need readers much like I do. What this shows is the number of Section 101 challenges taken at the motion to dismiss stage, going from 2013, in which we saw across the entire country very few of these, to 2016, in which we saw magnitudes of growth. So the net result of this is not only increased risk around the outcome of those 101 challenges, but the fact that procedurally they're taken at an early stage, and that has the risk both um, of a potentially adverse result for the patent holder, but also the risk of additional delay in ultimate resolution of the case. So what are the strategies for mitigating those risks? Again, looking at this from the context of the patent holder. One is it's important to have a sophisticated and well thought out approach to these potential delays right at the outset, and take the risk of delay head on when setting the schedule for the case. Upfront planning really does have the ability to potentially minimize the delay. So one very granular way in which this plays out, back before the AIA, IP rights holders who wanted to avoid a potential stay of litigation pending an inter-parties re-exam would generally follow the strategy of trying to front load a large volume of work so that they could credibly make the case to clients or to the court that the case was at too advanced a stage in order to warrant a stay, and that it would be unfair to the patent holder to stay the case because of how advanced the proceedings were. The calculus around stays with respect to IPR is very different. And in fact, we've moved in some cases kind of very much in the opposite direction, trying to recognize that IPRs are very frequent, and the primary focus then is encouraging defendants to pursue their IPR efforts at an earlier stage. So in a significant enforcement action that I was heading in front of Judge Robinson in Delaware, we actually agreed right at the outset that if IPRs were filed within a 6-month period, not the full year, but within a 6-month period, we would agree to an immediate stay simply upon the filing. And if they were granted, that stay would then continue all the way through the resolution of those cases. In exchange, though, we made it very clear that if the defendants waited until the very last day and filed on day 364, we'd aggressively avoid a stay or argue against a stay. And that, at least within that court, had the significant result of demonstrating to the court a significant desire to avoid the waste of judicial resources and to accelerate that phase of the case. And it was successful. One final point on mitigating this risk: not all PTAB activity is viewed the same, and certainly ex parte re-exams continue, and they remain available as a strategy for defendants who are seeking to challenge the validity of a claim. However, I would say that in many cases, patent holders, and I've been involved in arguments like this, have been able to successfully convince courts that by bypassing an IPR and the estoppel provisions that would apply to an IPR, a patent challenger is not seeking to resolve cases as effectively and efficiently as possible. And that has actually, that fact that there were other avenues that for resolution of the challenge that would be on a shorter timeline and would have definitive estoppel effect has been successful in convincing courts not to grant stays pending inter-parties re-exam. Last thing I want to talk on briefly is that overall these changes have increased market efficiencies. I'm now going to put on my economist hat and basically explain what I mean by that. That it's increasingly difficult to predict outcomes based simply on public data. The good news about that is it increases the value of technical and strategic expertise. So those that are sophisticated participants in the market, have that added advantage. And I'd also make the case that despite lots of press coverage about a change in overall patent enforcement activity, licensing and enforcement overall remains extremely active. 3 quick measures of that. First, anecdotally, the reduced enforcement that Tim alluded to earlier, I would suggest, is seen primarily at the bottom end of the market. low dollar, highly distributed patent troll activity has dropped off substantially. I've certainly seen that with my clients who are in the technology space and might be the targets of those types of activities. However, at the top end of the market, where there's true innovative value being licensed or enforced, those efforts have remained largely consistent. And one measure of that I see is that if we look at the last year for which the National Law Journal identifies top verdicts, 14 of those 100 top verdicts involved either patents or licensing disputes around patents. And that's remained roughly consistent through the years. And another key measure that my clients look at is that if we look at WIPO and other economic studies, on a more macroeconomic basis, they all show continued growth in licensing revenue generally. So the market, despite these changes, the market for licensing enforcement remains very active, and with proper strategy is a market that can be profitable for innovative companies. Tim?
Yeah, we're kind of running out of time here, but what I want to do is just get to the gravamen of the next module really quickly, and like I'm going to try to do this in 1 minute here. So I apologize. I'm going to advance to a slide in the middle of my slide deck here. What I'm trying to encourage, and this is part of the economic analysis that Chris was talking about, is that IPRs can be resolved relatively quickly, so even before filing. And do not underestimate the value of a well-crafted prior art search and the ability of counsel to educate opposing counsel on the weaknesses of the patent in order to try to get a patent assertion resolved quickly. So what I did is I put a chart together of the IPR timeline, and I've got 4 bullet points on here. And rather than going over all those in detail, I just want to make it clear that many of these IPR proceedings are being resolved before anything gets filed in the PTAB. Not only are they getting settled in the PTAB, but they're settled before the PTAB even gets the first document. So I think that for stakeholders, it's important to understand that the hard part is communicating your case to the opposing counsel so they understand the weaknesses, leveraging the other players that are at stake and at risk in this game. Because if you're one of several co-defendants or potential co-defendants, and you've got the strongest case and you're not about to educate the entire world on the weaknesses of the patent, a lot of patent owners will do a lot to get rid of that case and get you out of there early. So don't be deceived by just the statistics. There's a whole lot more going on underneath and prior to those statistics even being generated. The economic picture has shifted, and it does pose opportunities for those that are trying to get out of infringement claims relatively early to try to educate the opposing counsel about how that patent is going to bite the dust if we have to go all the way to the mat in the PTAB. Seeing that we're 6 minutes over, I'm going to just wrap it up with this, and I just want to thank everybody who tuned in today for the webinar. We look forward to any comments you might have on our discussion today, and we appreciate you coming and listening to us in this webinar. Thanks so much.